Um, so Jessica is an entrepreneurial lawyer who regularly advises employers on a range of employment, personnel management issues, in addition to her litigation practice. So Jennifer, welcome. Jessica, welcome. Thank you.
Thank you. Thank you. Okay, so today we're going to talk about independent contractors. What are the risks, right? So what is the difference between an employee and an independent contractor? And that question, it's not an obvious one. It continues to be the source of a tremendous amount of litigation, and especially at this moment, also legislation, attempts by state and local governments to try to tighten and regulate that issue when the economy is taken off in a different direction. So we're going to talk about basically three things today. We're going to talk about what is an independent contractor and an employee. We're going to talk about the consequences of getting that wrong. And then we're going to just talk about tips for how to move forward in light of some of those risks and potential consequences. All right, so we're going to talk about the test for an independent contractor. And I think a good way to do that is to think about a scenario where this will come up. So we're going to talk about a typical situation, which we're going to call Pat the plumber. Pat the plumber is someone who is an expert at plumbing, and I call up Pat the plumber to come to my office because our sink is not draining properly. So I'm going to call Pat the plumber, and I'm going to bring Pat the plumber in to do some work in my office. And we're going to set up a relationship. So we're going to talk about how that plays out in a little more detail in a minute. So set that as the scenario we're talking about. Now, how do I know what the nature of my relationship with Pat the plumber should be? Now, in general, there's no clear-cut definition of who is an independent contractor. This is something that varies by state, and it also varies by the entity that's looking at the issue. So there could be federal and state courts that look at it under a certain standard. The IRS has standards, local equivalents of the IRS. So any agency that deals with taxing in the state may have their own test. There's also workers' compensation issues and unemployment issues, and the National Labor Relations Board. There's a whole host of different agencies that look at this issue differently. And so we're going to talk generally about that and then go into a little more specific. To summarize it, historically, the approach has been to look at the level of control that the entity has over the service provider. So in this case, what is the level of control that my law firm has over Pat the plumber who comes into my office to do that work? And control is a major factor in general, but what does that mean? Like, how does that play out? So there's a bunch of factors, and we're going to talk about those that are going to be considered together when determining whether that control exists. Okay, so here are the factors. So the first factor is supervision, right? So we're going to use Pat's example, right? So Pat is coming in, and I'm a lawyer, and admittedly, I don't know a lot about plumbing. So Pat's going to come in, and yeah, I might look at what Pat does and make sure that Pat's actually working instead of just spending all day texting or doing something else. But pretty much, I want to see that the job gets done, but I'm not going to be able to tell Pat how she does the plumbing job. So that suggests, the less supervision suggests less control by the employing entity. And I use the word employee kind of engaging entity, the entity that's engaging the services. Other factors include how the work is being done, right? Is it being done day in, day out in my office, or is it project-based? Do we look at the amount of time that's being spent on the work, or is it more discrete than that? Next, training. So in Pat's example, she has a lot of experience and training in plumbing and probably is up to date on all the best technologies to clear the plug in my sink. So I'm not really going to be training her in any way, and she's going to have that independent training that she brings to the table. The next point is integration. So that looks at whether Pat is integrated into my business. I'm a law practice. I don't really need plumbers to do my work, and there's no really place for them to do work for my client services. So she's not really integrated into my business in any way. And that's a big factor we're going to talk about again in a minute. Next, you look at who does the work, right? So is it my employees going to go to help Pat to do the work? Probably not. My employees are not really set up to do that. They're not trained at that. Now, Pat may say, you know what, I'm very in demand. I've got a really booming business. And Pat may decide to bring in her cousin, Paul, to do the work, right? And so if I have that relationship with Pat and her company, I may not really care who does the work, and it may be that Paul can do it just as well as she can, and her job is to decide that in that situation. So that, again, suggests an independent relationship. Next is the length, right? The length of time that the project takes. So in this case, it's a pretty discrete project. And of course, contractors might have much more involved projects that last longer, but the length and then sort of the schedule, the frequency of work will also go to whether there is that control. So shorter term projects, not set a schedule, sort of with ultimate deliverables, tend to suggest an independent contractor relationship. Next is the order of tasks. Who's going to decide what gets done and how the project gets done? With Pat's example, she's best positioned to figure out how to fix that sink. And I'm someone who doesn't really have a say in that, and that's really her call. So next, the second column here is looking more at sort of the economic nature of the relationship. So components of that include the method of pay, right? How is she being paid? Is she being paid by the hour? Is she being paid by the project? Is she being paid on deliverables by like getting certain parts of the project done? The method of pay, the more sort of discrete it is, the more likely it's to be independent contractor. So for example, if it's an hourly approach, then if she takes 15 hours to do a project that should really take 10, I have to pay her for that time. And that suggests more control by me. Whereas if it's a project-based approach, she can engage me and set a price and say, okay, it's gonna cost this much to do this project, and she's gonna decide how to use that time. So the more project-based approach suggests more of that independent relationship and a lack of control by the engaging company. Next is tools and supplies, right? Law firm doesn't have a lot of plumbing supplies around, so obviously she's going to come with all of her supplies and going to provide what she needs to do the job. Next is profit and loss, right? Who's taking the risk on this relationship? If she comes in and I engaged her and Pat makes a mistake and ends up taking 5 hours longer than expected, right? Who's going to bear the loss? Like if I'm paying her hourly and I'm controlling how she does it, then I'll be paying her extra. Whereas if it's more discrete, she's going to decide how to allocate her resources, and it's more likely to be independent. Another factor is the availability of this person to do work for other companies. So if Pat is, again, in business, she's got all kinds of clients all over the place, and she may work at 4 or 5 different clients on one particular day. That suggests more independence than a longer term relationship with full-time hours. And on that next point, we talked about services that are available to the general public, right? She's opening her doors to be available and to find clients, and she's not necessarily only committed to me. And then finally, the nature of the relationship is such that it's terminable at will. In other words, she could just walk away at any time, suggests that it's more of a control situation, an employment situation. Whereas if she's committed to get me a deliverable and she walks away and doesn't provide that to me, I may be able to, I will have to negotiate with her because we have a little bit more skin in the game in that sense. So now that I've talked about all of these factors, I'm going to throw a little wrench into the mix. So to the extent any of you have workers in California, there is a major development about 6 months ago that came down from the California Supreme Court. And historically, California had followed the approach of, we're going to follow this right to control test where we measure all these different factors and then weigh them and come up with a solution. And the California Supreme Court recently said that under the laws governing wage and hours, certain factors are going to be more important than others. So the first test is, and they call it the ABC test. First test is control, right? Like these factors that go to control and who has the power in the relationship are going to be important, but they are not the only ones. The second part of that test is whether the service provider is outside of the mainstream of the work of the business. So it looks to that fourth bullet point, integration, and kind of highlights it and makes it much more important in that the economic relationship is not so intertwined. So in the Pat example, I'm here at my law firm and Pat is here and she's doing nothing related to my practice. She's completely independent and has no relationship to the work that I'm doing in the business that I do. And the Supreme Court, the California Supreme Court has now highlighted that as a necessary part of the test. And then finally is the degree of independence that person has, that they're in business for themselves, and that they do the services that they're doing for my law firm. So Pat's services for my law firm are services that she does for other people. So looking that she makes herself available to the general public and does this nature of work, this plumbing work for other members of the public. So, like I said, there's not just one test. And the one that I described here on the screen, this control test, is one that's historically been the approach, but not universally, and different agencies and courts have weighed different factors accordingly. But California has kind of come in now and recently said, like, to the extent there's a claim for wages, we're going to look much more at the economic relationship between the parties, and it's not just about control. It'll be interesting to see whether other states follow suit. In that case, the state was following its own regulatory guidance with respect to this issue. So, it remains to be seen what's going to happen. But as we'll talk about in a few minutes, there is a little bit of a trend of kind of tightening the noose a little bit on the use of gig workers. So we're going to talk about that as well. Moving on to our second area of discussion today, the consequences of misclassification. So this is really important because when you're setting up your business and you're figuring out how to weigh your risks and your business objectives, it's really important to be mindful of these things because hopefully your business is going to take off and be wildly successful. And if you've gone down a path that could lead to a lot of risk, as you grow, that can put more pressure on you and cause distractions that you might not want from your business. So areas of concern are wage and hour, audits, and lawsuits. So the example would be like an overtime claim. So if Pat comes to my office and spends 10 hours at my office, and I'm in California where you have to pay overtime for hours worked over 8 in a day. And she later claims that she was entitled to 2 hours of overtime pay. She may bring a lawsuit. And there are certain protections we can talk about in a minute about how to sort of try to create some contractual protections, but she might also go to a government agency. And the government agency may say, this woman was misclassified and you owe her overtime. And by the way, we're going to look at all the other people who perform services for you and you need to turn over all that information to us. So it's an area where you want to make sure you get it right, because if you don't pay in the right way, obviously, as time passes and you grow, the more people who have situations where they might be improperly paid, can compound and can get more expensive. Also, penalties can be owed as well. So if you don't properly pay someone, you might owe penalties or other kinds of interest. Next are employment discrimination claims. So historically, companies have not been liable, can basically say as an excuse or defense from discrimination or harassment, this person's an independent contractor and they're not protected by the laws that protect people from discrimination and harassment. And so if you operate under that assumption and you don't kind of come up with, you have like a bunch of, let's say, gig workers, right? So I'm going to define gig economy as people who come on a discrete basis to do a project, for example, on Uber, right? The drivers are classified as independent contractors. They come in to do a discrete project as part of the business, and it allows them to do, just a few hours of work here and there. And so let's say an Uber driver, for example, makes a claim of discrimination. The company will probably say, no, that person's an independent contractor. I don't have to prevent them from discrimination. So that could, if that person feels they've been wrong, they may bring that lawsuit, or they may bring it to a government agency, and you'll have to kind of litigate that question of whether they're an independent contractor or not. Similarly, if you are paying someone as an independent contractor, you won't be withholding payroll taxes, Social Security, Medicare, and then local unemployment, withholdings and sort of disability, all those insurances that you would ordinarily get or fund through payroll, you won't be doing. And so state agencies in particular are very interested in making sure that their coffers are filled with resources. And so they tend to take a very close look at classification issues and want to make sure that employers are paying into the system through their employees. And if you don't withhold those taxes and are found to have misclassified workers, then you might owe those back taxes. And if it should have been withheld from someone's paycheck, and you didn't do it at the time, like a lot of times the agency will just say, okay, you'll pay it then instead. So you'll pay more than you would have otherwise. Another really important consideration that I think gets possibly overlooked is the potential for injury. So if a worker is doing something that's pretty physically demanding and they're an independent contractor and they get injured, if they're an employee, you would have gotten workers' compensation insurance for them, and it means that they can't sue you or your business for personal liability for that injury. So they get injured and they have like a $50,000, let's say that's probably cheap, like a $50,000 injury, right? And they can't work and so suddenly that claim, if it were covered by workers' compensation, they would be able to process it through that, and then it would be handled by insurance. Whereas if you don't have workers' compensation insurance for that person, you or your business, more likely your business, can be subject to liability and have to pay that out of pocket, potentially. And then finally, there are areas where there are claims of benefits like unemployment, Social Security, health insurance, family leave. So things that an employee would get as an independent contractor, you're not paying into those systems. And so later that can kind of come back to haunt you. And I think the more classic example that I've seen is where you have an independent contractor, you decide you need to lay them off, like you don't have enough work for them. So they file for unemployment. And then the unemployment agency says, we have no record of this person. Who are they? What are they doing? And you respond, well, they're an independent contractor. That is what I've seen a lot of what leads to government investigations, because suddenly you've got this person who says, oh, but I thought I was an employee. And then you're disputing it with the agency, and then they start to kind of look beyond that. So that's kind of a scenario that comes up really frequently. Okay, so moving on to some strategic considerations. What should an agreement contain, right? So let's say you've decided that Pat is going to be your independent contractor and you want to formalize the relationship. So it's a really good idea to specify the nature of the work being performed. And contracts are important, but they are not the end all, right? But if you don't have a well-written contract, it's going to be really hard to defend the classification of someone as an independent contractor. So things that should be considered are the worker status. So in Pat's case, what is she being engaged to do? She is being engaged to clear the plumbing in my sink. And she's going to do that project, spell it out. That helps to ensure that there's not going to be a question about who's doing what and when. Importantly, you should also spell out everyone's responsibility. So in the example we used a few minutes ago with a potential potential personal injury claim, let's say Pat gets, dings her finger and breaks her finger and can't work for like 3 weeks, right? And she wants to claim, oh no, I was injured and you guys need to pay for it. And so you want to make sure you put in there, you should put in the agreement that Pat's responsible to get her own workers' compensation coverage so that she has, it's set out what her expectations are. She should get good liability insurance, right? So that she's not going to come after you. Something I didn't put in here, but is a good thing to consider is also indemnification. What happens if Pat injures someone while she's doing the work on my premises? So let's lay that out. And obviously, if you're the company engaging Pat, you're going to want to be strategic and make sure that she's going to take responsibility for what she's doing, and that she's not going to try to come after you. Also, you want to lay out strong language about tax obligations, that, she's a 1099, nothing is going to be withheld. She has responsibility for her tax reporting, and that she's going to, also indemnify you if there's some issue with taxes. Next, you would want to talk about licensing. So if Pat needs a license to do business, you want to make sure she has the right license and insurance requirements, and you want her to lay that out and represent that she is, properly covered. So this all goes to the same issue of like a B2B tone, right? Like businesses, right? It's a relationship at arm's length between two businesses. And so the more you can make it look like that, the more likely you are to establish that independent relationship. So, for example, one important consideration by some agencies has been that I'm doing, as me, the law firm, I'm doing business with Pat's Plumbing Business, Inc., not Pam Schneider, right? It's like the person you're doing business with, her business, not her as a person. And in fact, some agencies really care about that. And I've had audits where they focus exclusively on that issue. It's not a guarantee, but it's a way to add that additional level of protection. And then finally, and probably most importantly, is an arbitration clause with a class action waiver. Because this is where if you get it wrong and you misclassify your workers, and you have a large number of workers that are at a risk of suing you for certain things, if you include a class action waiver, there is a very strong likelihood that will result in individuals having to bring claims themselves and not being able to band together to bring a claim. That's really important because class actions are extremely costly to defend, and they become less about the merit and more about kind of the risk and the cost of defending them often. So just to give you a little bit of an anecdote, there's been extensive litigation over the last several years involving Uber drivers. It's been pending in California. And Uber, so in that case, like there wasn't such an issue of overtime because a lot of these people are working kind of small shifts. But under California law, those workers are entitled to get their expenses reimbursed. So the focus of those cases has been on people having incurred expenses, business expenses that were not properly reimbursed, and they were trying to get reimbursed and get penalties for those. And the litigation has now evolved, and kind of there's been some key developments recently into a question of whether whether the arbitration clause is required and whether they are allowed to bring their claims together as one or individually. And the Ninth Circuit recently came down and said, in light of some recent Supreme Court precedent, these people have to bring their claims individually in arbitration. And that's a really big deal because it makes it less desirable for a plaintiff's lawyer to bring a case in that way. And it also means that the company is going to have to defend individual claims. So it has its own issues associated with it, but faced with the difference between a class action and an arbitration for each individual claim, the company has decided that they would prefer to go with the individual arbitrations, kind of hedging that a plaintiff's lawyer is not going to have as much interest in a small number value for an individual. So looking at what the contract agreement shouldn't have. So as we talked in the factors before, the more discrete a project is and the less control suggests more of an independent contractor relationship. So if you put in there that the worker needs to show up Monday to Friday, 9 to 5 or 9 to 1 or whatever the schedule is, that suggests a level of control and it undermines the independent relationship. Now, next is the question of salary, right? The more discrete the project, the less likely it is to be, more discrete, the more likely it is to be an independent contractor relationship. So if you want to show independence, you don't pay someone a salary, you pay them on a project basis. Next, the big one is benefits, right? You might be like, I want to take care of my independent contractors, but if you do that, it suggests that they are not independent because when someone's in business for themselves, they get their own benefits and they handle it on their own. Same with expense reimbursement. That one comes up a lot where clients want to reimburse expenses and be sure that people feel that they're being taken care of. And that kind of flies in the face of that independent contractor relationship. So it's not a good idea to provide that. And then perhaps obvious, but not always, is like the training and performance review. Like if you want to be able to control what someone is doing and how they're doing their work, independent contractor relationship is probably not a great fit because that flies in the face of the test, right? And so the more controlled over what they do and how they do the work, the less you're going to be able to really truly claim that they're an independent contractor. So you don't want to put that in agreement.
I have a quick question about that. Is that okay if I ask a question? If we do any sort of review over their work, is that considered a performance review, or is that just reviewing the things that you've hired them to do? Like for the rest of the things that you've listed, I wouldn't say I've done any of those things, but I definitely want to make sure that the person I'm hiring is doing the correct work. Is that considered performance review, and would that be indicative of an employee?
Yeah, good question. So I think you're going to look to sort of, with the example of the plumber, right? Go back to that one. She comes in, she does the job. I'm allowed to say if the job she's done is adequate, right? If the drain is still not working after she does all her work, I'm going to say this is not adequate. You need to fix it and get it right. So there is still some ability to have some sign off on it, but to the extent you're checking in on a regular basis on their performance to be sure that they're doing it right in the right way that you want, suggests more of a control relationship. Did I answer your question?
Yep, I think so. I just if it's like not like physical labor, it just seems like a gray area. But yeah, I think so.
I mean, can you, without going into specifics, because I'm not giving you legal advice and you probably don't want to go on record with that, can you give me sort of like a general sense of what kind of review you're thinking of, like just generally?
Yeah, like if someone's on a sales call, I'd like to review like what it is they said and how many, say they make 100 sales calls and nothing comes of it. I need to make sure that they're doing it accurately and not, like maybe I'd listen in or maybe I'd record it to kind of see what's going on and why it's not leading to any business or something of that nature.
Yeah, so it's that type of checking in, I think, does suggest that there's some oversight. Of course, that's not the only factor to consider, but if one were to do that, let's just say hypothetically, not necessarily you might want to do it in a strategic way to so if it were required, you might want to do it in a strategic way to kind of make it look like you're giving less guidance and more kind of, let's see. Right. So to make it look less like you're reviewing their performance and more like you're serving as a resource that they can take or leave. Right. So it's kind of in the messaging and how you do that. And it's still, it's a little bit of a delicate line, and I'm happy to talk about that with you offline. But it's the kind of thing where if you need to do that and you're still going to like keep an independent contractor relationship, you might want to draft the contract in a specific way, in a strategic way. So taking into consideration that component.
But if they're a business, it might be easier. So like, let's say this individual he had his own sales company. So then it's like a B2B relationship.
Yeah, I think that definitely helps, because that suggests that that person has the expertise. And you might say like, this is not our methodology. This is, if you're going to be doing it in this way, our preference is that you have that this is the outcome in the way you do it. Right. So if I'm engaging you as a business, there is a little bit more of that arm's length relationship, and there still could be control if you're not careful. So you kind of need to frame it very carefully.
Got it.
Did I answer that question? Thanks. I'm only hesitant that I don't want to be giving, like, we'll say at the end, like, I don't want to give legal advice. So, I'd rather let's answer your follow-up questions on that. If there's like a specific scenario, I'm happy to talk about it offline. Don't want it to sort of go out there into the internet world. So next we're just wrapping up. What are some strategic considerations? We talked about this, but it's important to know what the factors are, right? And consider them. So if there is some level of oversight, maybe you're not in California, you look at the other factors and see, like, I think like Tanya alluded to, can you balance the other factors in a different way, so that, my suggestions about how you do this work are just suggestions and maybe not mandatory, right? And if you don't follow them, I'm not going to have punitive response, like a punitive reaction, like you would with an employee. So there's ways to sort of to strategize that and to just be mindful of all of the factors. And again, to carefully draft your independent contractor agreements. And if it's a reality that you have independent contractors and you need to control them, then you might strategically draft your contractor agreement to be less detailed, right? And that's something that you should do carefully with the advice of a lawyer, to consider all the potential strategies around that. Because a court or agency will look beyond the face of the contract, like I said. But the contract is a first step and a first look. So going to this third point, which we touched on a little bit, is branding, right? If you feel like you want people to do work in a very specific way, and you want them to hold themselves out as your workers, like wear your t-shirts or have a business card or have an email address with your business or post on your social media as a representative of your business, that suggests more of a control relationship. And it also, from a practical and business standpoint, may mean that if you're trying to kind of show a hands-off approach to fit within this paradigm, it might mean that you have less control and, as a practical matter, not be able to ensure that your brand comes across, right? So I think there were some delivery services out there that started as independent contractors, and they found that the workers just weren't showing up. They weren't really invested in the business, and they ended up making them into employees because it really enabled them from a strategic standpoint to just create that better appearance of a unique brand. What may be good in the short term for money, your pocketbook, because not paying as many taxes and having other advantages, financial advantages of having independent contractors, it's good to think more strategically, like from the business standpoint as well, as like, if I really want to follow this test and try to make these people look truly independent, is that going to have an impact on my relationship with them and my ability to make sure they're representing my business well? Finally, this is a really quickly changing area of the law. The law is trying to keep up with the reality of the gig economy. 15 years ago, this was probably still an issue, but not nearly to the degree it is now. And so courts and legislatures are trying to keep up. And so one example is that the California Supreme Court has taken like a more expansive approach than historically they had. Another example is in New York, where the law recently changed so that independent contractors of a business are protected from sexual harassment, meaning that if they are experiencing some harassment in the workplace, the company that engages them could be liable to them for that harassment. It's kind of mind-bending, because I just told you a few minutes ago that historically companies are not responsible for discrimination and harassment, but literally the New York state has turned that on its head and said that sexual harassment prevention in the wake of Me Too is so important that it's going to provide additional rights to people who are independent workers, and especially gig economy workers who may not have the protections. So that's a situation where you're supposed to, effective last week, companies in New York are supposed to have a harassment prevention policy and do training. And those policies should reference individual independent contractors as well. So in an area where you thought like, okay, I can make everyone an independent contractor and I can avoid overtime, I can avoid, worrying about claims of harassment and discrimination, it's not that easy yet. It's not that easy anymore. So it's something to keep in mind, and I wouldn't be surprised if other jurisdictions start following suit. Finally, as we must, this is not legal advice and should not be construed as that. And as I mentioned, these areas are very, very, obviously have a lot of implications, and the approach that you take, for example, in drafting a contract should be really carefully considered, because you're going to have to live with that contract for many years and potentially litigate it. So it's really a good idea to get good legal advice that's specific to your business. And now I'll take any other questions from the crowd.
Daniel, do you have a question?
I'm trying to look over my notes. One moment. So any of the work performed as if I was hiring an electrician to come in and fix a electrical outlet would imply independent contractor. But if I dress someone up in my polo shirts with logos and have them pass out flyers, that implies an employee relationship, right?
Yeah, I mean, I think that's so this is kind of a simplistic approach to it. I hope the takeaway was that it's complex, right? In general, yeah, if you can, the perfect example is Pat, the plumber, right? That's like a great example because it's really a business relationship. And I realize that in giving that example, it's a little extreme. It's an easy case. The harder case, and the ones that you and your other business owners are going to be faced with, is if you really want to have like a gig economy relationship where you've got people doing discrete tasks and coming in for a quick project and then done, right? And they're wearing your logo and handing out your flyers, like that's maybe more realistic. And I think that's a relationship that you would need to look at closely when figuring out whether those people should be employees or independent contractors, right? I'm not going to say like, what's the right example, right? What's the right answer, because there are so many factors to consider. But it's that is the type of situation that could lend itself to an employment relationship. But it would just depend on a lot of other factors as well.
Okay.
So we probably should be looking at Uber in a sense, because Uber has your logos, they have their branding. So see how they're navigating the law there.
Yeah, well, so they have pushed the boundaries, right? They have like really pushed it and are trying to have aggressively approached this business approach to providing their service. The drivers are in the course of the business; they are integrated to the business. Now, Uber has said that they're a technology company at times, and the drivers, but without the drivers, at least right now, until we have driverless cars, like the business doesn't run, right? So they are integrated into the business. And there are even like some of the cases that have addressed this have looked at like Uber had instructions on where the driver should pick up a passenger to be sure that the passenger wouldn't have to step into traffic. Like you should pull over and you should have an umbrella in your car and you should have music playing. Like they do, historically have had a branding approach, to try to create that, that kind of consistent brand. So it is, I think you're right to say that it's pushing the boundaries of what has historically been considered an employment relationship. And in the course of the many years of litigation, it's now turning into a question of there's going to be arbitrations over this decision, over this issue, and those will be private arbitrations. So there's not going to be like a lot of court guidance then on whether those indicia lead to a conclusion of independent contractor or employee.
Got it.
Any other questions?
I think you covered it all. The only other one would be if you're dealing with international. Let's say you're hiring a virtual assistant or other people. How does that impact? Is it the same thing or?
That's a great question. Where someone performs service is typically, the law that applies is typically the law where they perform services in the US, right? So if I'm in California and providing services to a New York company, California law is going to usually apply in that situation. And so you would look to the law of the place where someone's performing services. And because then there's all kinds of taxing issues and, other issues that come up. And I know this is an area where I think a lot of business owners are using overseas workers. So the analysis I would undertake is to sort of at least when you're structuring those relationships, perhaps consult with a local lawyer in that area. And I've made referrals like this to clients, like you should talk to a lawyer in this, in Europe, in this country, in Spain, for example, to hear and make sure that they agree that this approach makes sense. Because, I lost that. Because this is the kind of thing that can really lead to, this is the kind of thing that can lead to some issues. And so I think it's important at least to be mindful at the beginning when you do that of what the potential stakes are.
Great. I guess that's it. Thank you so much, Jessica. This has been fantastic and very insightful.
Thanks so much. Thanks for the opportunity to talk to you and for your really great questions. And, if any other questions come up, happy to address them offline.
Excellent. Thank you.
Thanks.
Thank you.